So we are now moving on to E2, presentation of the Brown Act from the City's Attorney's Office, and I would like to introduce John Lee from the City's Attorney's Office.
I'm just going to speak to the mic if that's okay. While my presentation is getting loaded, I just want to sort of let you know that I'm going to try and keep it short and sweet. There will be an opportunity for questions afterwards, but I really wanted to do this presentation fairly quickly. Part of the reason is you guys have a lot of important work ahead of you, and the training is important, but you will have the opportunity to have the presentation that I prepared, so you can always look back at it for reference, and then you can also, if you have any questions, you can facilitate it through staff, and they'll contact me, and I'll certainly be in the loop. So don't worry too much about sort of, analyzing this too much. I'm going to try and go through and make it fairly straightforward. So obviously we're doing a training on the Brown Act and conflicts of interest, the Neighborhoods Commission. So here's an overview of my presentation. I'm going to talk about commission meetings and how the Brown Act interacts with that, the City Sunshine Ordinance, also conflicts of interest, primarily the Political Reform Act, and then also any policies or code ordinances that relate to that topic. And then there are going to be a few just commission do's and don'ts to kind of illustrate the points that I'm discussing. Okay, so you see you've got 2 bullet points here, purpose and scope. The purpose of the Brown Act just really simply is that the conduct of the people's business should happen in open public meetings. It's just that simple. And the scope is that it applies, the language that's used in the Brown Act is legislative bodies, but it also includes boards, commissions, and subcommittees. And by the way, the Neighborhoods Commission is included in that list. One exception is ad hoc committees. Those are primarily committees composed of sort of a subset of the body, less than a quorum. You should note that the Sunshine Ordinance Resolution, or the Sunshine Resolution, actually has a time limit on ad hoc committee terms. The purpose of having it shortened is the idea is that it's not like a standing committee, it's not like the commission, it actually has a limited charge and it only lasts for a limited amount of time. Alright, so as I mentioned already, the general rule is that all meetings have to be open to the public. A meeting is any congregation of a majority of the members of the legislative body, in this case the Neighborhood Commission, that meet at the same time, and this is the key language. I've bolded and italicized here because it's sort of the lowest common denominator. So it's hear, discuss, deliberate, or take action. So even just hearing is enough to sort of trigger the conclusion that it's a meeting. All right? And of course, it's for items within the subject matter jurisdiction of the Neighborhoods Commission. So I'm sure many of you know, and those who don't, it has to do with sort of neighborhood livability and primarily, safety, traffic, and things of that nature. And that's actually set forth in the Muni Code in Chapter 2.08. The following items here are not meetings. So you've got individual contacts with members of the public, attending a conference, an open and publicized community meeting, attending an open and notice meeting of another body, so for example, like the City Council. There is a little note there about serial meetings. Generally, in the past, what I've advised is when you meet, when you appear in these meetings, it's generally a good idea that if you guys do congregate, not to discuss sort of the subject matter of the Neighborhoods Commission, any items, because then you can get into situations where there could be meetings outside of this particular context. And any social function. Prohibited serial meetings. Now, I sort of alluded to this. So, a serial meeting is where you've got a majority of the members, there's a series of communications, or they can actually act through intermediaries that can include staff. Sending emails is another sort of trap, to discuss, deliberate, or take action on any item of business within your subject matter jurisdiction, which I've already discussed. There are 2 types, daisy chain and hub and spoke. Daisy chain is an instance where you've got Commissioner A speaking to Commissioner B, and so on and so forth, and they just kind of eventually the information starts to sort of coalesce and you've got a quorum of folks meeting outside of an open meeting. Hub and spoke is more a situation where you've got one individual who's sort of orchestrating it all. That would be the hub, and the individual folks that are being spoken to are spoke. I wouldn't make too much of it. The general understanding of serial communications and serial meetings is that just because you're outside of these four walls doesn't necessarily mean that you're not engaged in a meeting, and that's sort of the idea. Staff briefings are allowed. It's primarily for information exchange. The important part is that there aren't any comments or positions about the other commissioner, and we can get into some detail about that a little bit later. Agenda items. The Brown Act also discusses agendas and when they should be posted. But generally the idea is, it kind of plays off of the idea that all the stuff that you guys do should be an open meeting. So the idea is, the agenda is really to notify the public about what you guys are discussing, because not everything that you guys discuss is going to be important to a particular member of the public. So it's important to make sure that these descriptions are brief on the one hand, but then also provide enough information for a member of the public to let them know that here's an item that you might be interested in, you might want to go up and speak up about it. Okay? Okay, the commission should not discuss items that are not posted on the agenda. Kind of going back to what I was saying, you don't want to, the whole purpose is to have things open so that there's, robust public discourse on a particular topic, and you can't have that if you're discussing items outside of the agenda. So it kind of keeps, the parameters to whatever it is that's on the agenda. Let's see here, comments by commissioners regarding unagendized items. So there are exceptions, and sometimes this will happen. The most common way to deal with it is to sort of agendize it for future discussion. But essentially, you can respond to a public comment as long as there's not this sort of back and forth and long deliberation. You can ask questions from staff for clarification. You can refer items to staff. You can get brief reports. Sometimes commissions will have sort of ad hoc committees that do certain things and they'll come back and report. Like if there was, a portion of the general plan that was being updated that you wanted to know about, you could send a delegation out there and that person would report back and that would be okay. All right? Public comment. The public, as you all know, or if you don't, can comment on items on the agenda, but they can also comment on stuff that's not on the agenda as well. Let's see here. And these comment periods can be combined. Sometimes you'll have members of the public who will come and speak and they may be disruptive, and the chair is empowered to rule these speakers out. Generally, the chairs that I've experienced are very permissive. You can, and the whole purpose is that you can't have a meeting if the member of the public is being very, very disruptive. But you should keep in mind that that rule is also very, very permissive, as it's been sort of construed in the courts because of the First Amendment. So you have to be careful about that as well. One sort of tip that I've seen is when a member of the public is becoming disruptive, you can take sort of a recess, kind of cool things down. That way you're not actually, booting them out. You also can enforce time limits, but keep in mind you have to enforce them equitably, so you're not getting more time to one person over another person, because there could be a fairness issue there. And, when the member of the public comes and talks, criticism is fair game. They can say, that they don't like what the Neighborhoods Commission is doing, and that's perfectly fine. So the Brown Act tells you when you actually have to post these agendas, but it sets only the floor. We have a sunshine resolution that makes it a little bit more aggressive. So for regular meeting agendas, it's usually 72 hours. For special meetings, you'll note it's 24 hours. Just going to note the highlights here. But under the Sunshine Reform Resolution, it's 7 days for a regular meeting and 4 days for a special meeting, unless you've got 2/3 of the members agreeing that it should be. So staff reports are 7 days, and those are the most important ones. Let me see here. Okay, now onto the Political Reform Act. This is essentially conflicts of interest, okay? It was adopted in 1974. What it requires is that if you've got a disqualifying interest, then you have to recuse yourself, essentially. And so a public official has a disqualifying financial interest if the decision will have a reasonable foreseeable material financial effect, separate from what effect it would have on the general public, on the official or his or her immediate family, or any other listed financial interest. Okay, so the decision. It's not just making a decision, it could be attempting to influence a decision. It includes making recommendations. You should pretty much assume anything that you guys, any action you guys are taking is going to be a decision. Financial interests include sources of income for your family, gifts, involvement you may have in business entities, real property you might own, and also your family's personal finances. Material means significant. Okay, there are specific tests in the FPPC regs that I won't get into, but that's sort of the idea, that it's got to be a significant interest. And it's got to be reasonably foreseeable that there's a material interest. And that's also determined by FPPC regs. So, for sources of income, it's $500 or more. It includes your income, any promised income, so even if there's no money exchanged hands, the income of your spouse, domestic partner, or child, and any loans that you may have been given. Real property interest, $2,000 or more. This can be sort of direct or indirect. Again, spouse, partner, child's property, leasehold interest, except for anything that's month to month. There's something called the 500-foot rule, and essentially what that means is this occurs most commonly in the planning context. You'll have planning commissioners who have projects that come before them that are really near to the property, and it's governed by the 500-foot rule. So it's within the 500-foot sort of radius of where this individual commissioner lives, then they have to recuse themselves. One thing you should note about the 500-foot rule is that it's not actually a bright line rule anymore. It used to be, so even if you're outside of the 500-foot rule, especially in cases where it's sort of on the threshold, you may need to recuse yourself. Other kinds of interests, gifts you might receive, businesses, so any position you might hold. So for example, if you're a trustee or an executive of a business, that might have business that come before the commission. Investments you might have, contracts that you might be sort of seeking to have with the city that is being approved by the Neighborhoods Commission. Any personal biases or interests you might have. Personal bias usually comes up in the due process context when you're talking about adjudication, or when a body like the Neighborhoods Commission acts in a quasi-adjudicatory capacity. It doesn't necessarily come up here, but it might come up when you sort of have demonstrated personal bias against a particular individual. And then personal finances. If it impacts your personal finances, not just income, but like your expenses. One example I have is, in my prior job, I advised a rent board, and there was a decision they were making that would actually impact their rent. So that would be an example of a personal finance impact, okay? So if you think you have a conflict, the best thing to do is recuse yourself. What happens is you'll sort of state it on the record, you'll refrain from discussion or voting, so that there's no appearance that you're attempting to influence a decision. You're technically not required to leave the dais unless you're trying to comment on the item as an individual member of the public, in which case you should leave the dais and just come up to the mic as I am now. Under FPPC regs, as I mentioned, you can leave to comment as a member of the public, but keep in mind that recusals can actually affect voting and quorum, and it can cause quorum issues. So for example, if somebody has a legal conflict that requires them to recuse themselves, like for example, if they are the individual that's actually coming before the Neighborhoods Commission to get something approved is paying one of your salaries, and that's a legal conflict. Whereas another conflict that might not be legal is if there's an appearance of bias. So the 500-foot rule, you're kind of outside the 500-foot rule, but you want to recuse yourself because it just doesn't look right, and it doesn't pass the smell test, so you're just recusing yourself in an abundance of caution. It wouldn't have an impact on quorum, but the point is, if you do have a legal conflict, that means that you, as an individual, will not count towards a quorum. And that's important because you need at least 11 members of this body to take any action, right? General functions, powers, and duties are all set forth in Chapter 2.08. There are attendance requirements. You can be what's called deemed resigned, essentially, or automatic resignation if you have a certain number of unexcused absences. So 3 consecutive regular meetings or more than 20% of the meetings in a year. The excuses that will allow you to excuse your absence would be like an illness, of the individual commission member, or perhaps illness or death of a spouse, partner, child, or sibling.
I have a question.
Sure.
What about the birth of a child?
The birth of a child. I don't know that that's necessarily covered, but I'd have to get back to you. I don't have the code in front of me. That sounds like a very, important one.
I have it October 25th. That's
October
why I'm asking.
25th. Come see me.
Okay.
Talk to me about that, and we'll discuss that.
Thank you.
Sure. You must attend at least half the duration of the meeting. So some folks will attend a portion of it that sort of is that they really need to attend, and they'll take off after, and that would count towards attendance, and it wouldn't be counted against you as an absence. The council may reappoint the member if they find good cause for these absences. So for governance requirements, the chair is appointed by and can be removed by the commission. Okay. And originally there was rules and regulations, but it's really bylaws that govern you, and if the bylaws are adopted, as far as I can tell, there haven't been any. It should be based on Policy 04, the Policy 04 template, and Policy 04 was just revised last night, and it was adopted by the council. And you should prepare the bylaws with my assistance. I would be reviewing those for you, and once it's adopted, it should be posted to the web and filed with the city clerk. Quorum, as I mentioned, 11 commissioners, and I believe you know the terms of how long they'll be serving. So as I mentioned, Policy 04, I'm not going to go over Policy 04. As I mentioned, it was just adopted. As I understand it, there's going to be a full training for you guys on this. It's going to be conducted through the city clerk's office. The tentative right now is going to be January 2017, but of course, if you want to request an earlier training through staff, you certainly can do that. It deals with recruitment, selection, appointment, resignation, requirements of board members and commissioners, board and commission governance and operations, codes of conduct, which are really important, and the authority of the boards and commissions. So let's get to the do's and don'ts. Do make recommendations to the council that are of the commission as a whole and not unduly influenced by any particular council member, city staff member, or outside entity. Do refrain from participating in any discussions if you have a real or perceived personal bias or conflict of interest. I would add to that you want to recuse yourself in an abundance of caution, even if there's an appearance of it. That's very helpful. Do make recommendations on the topics within the scope of your authority set forth by council. Again, that's stated in Chapter 2.08 of the Muni Code. Don't use your commission title in making personal political endorsements. Don't use your commission title or speak as a commissioner unless authorized by the commission. That's very important. Sometimes when you appear before the city council or any other board, commission, or body like that, it's important to have, if you are speaking on an item and you want to make sure that you distinguish that you're speaking as an individual, or if you've been duly authorized to speak on behalf of the neighborhood's commission, then you should so state. Do use city stationery. I put emails in there because that's also important for official commission business only, and all correspondence concerning the commission's business should be sent with a copy to staff so that they're aware. Don't interview candidates for political office or make endorsements. Do make requests for information or research from staff through the Rules Committee, if it's just more than just copies of existing information. Don't individually or as a body independently support or oppose legislation, including ballot measures, which I understand we've got a few coming soon. Don't contact city consultants outside of the commission meeting unless authorized to do so by the city. Don't represent the city or commission in front of other non-city entities, such as VTA or the county, without express approval from the council. And that's going to be in Policy 04, and you'll see that once you get your training. Do place items on the council agenda in accordance, or on your agenda, and also when you recommend things for council agenda in accordance with the rules resolution. Don't accept money or favors. Don't use confidential information, and the laws don't discriminate against anyone. All right. Thanks for participating. Any questions? Go ahead, right there. I saw that first.
Okay, I have a question regarding the outside work. I'm heavily involved in some of the stuff that's going on with VTA. As a member of District 1, not as and as a private citizen. That's not an issue.
So your role, so what do you do for VTA, excuse me?
I've been attending some of the meetings,
Okay,
and that was before I was appointed to the commission.
yeah. Yeah, I don't know that that's necessarily, the idea is you don't want to be representing the neighborhood
Right,
commission.
Right,
you know,
I'm
say that.
representing myself as a resident of District 1 in San Jose, not as a member of the Neighborhoods Commission.
Sure. You know, not knowing any further facts, I mean, it doesn't sound like that would violate anything, but, you know, keep in mind that Policy 04 is evolving. I don't know it all that well, especially because it was adopted last night, but there's also direction from council for certain aspects of it, so it's kind of a moving target. So once that comes out, when you have your training, you should consider that question in light of that training.
Yeah, because my city council member recommended me to go to these meetings, so.
Sure. Yeah, no, I understand that, and, but, you know, compliance with the law is different. I mean, the city council may make recommendations like that, but it's important that if you have any questions that you come to us to ask us, and I'm glad you asked that question. But as far as I can tell, no, I don't know that it would necessarily be an issue, but
Okay.
keep in mind that Policy 04 is changing, and you can always come back and contact us once you've read 04, you've had the training on 04, and you think there's an issue.
What I'm working on is Next Network.
Next network.
I'm participating in the meetings that they've been having.
Okay, and when you say participating, are you,
I went to one of the meetings and actually,
but you're not, okay,
and actually was a part of a group of people that did some of the exercises.
yeah, I don't know that that's necessarily an issue. I don't think that you should be too concerned about that.
Okay, I won't.
Next question.
Thanks.
Yeah, the quorum I thought was a majority, 11.
Gary, can you speak into the mic?
11 is only half, would there be 12 as a quorum for us? There's 22 members?
Or there are 22 members? My understanding was it was 20.
No, it's 20. Oh, I'm
20.
I got it.
Okay.
I'm not, okay. The other thing was, can you attend any meetings of this commission by phone?
So there are particular rules on that, and the way it works is, it's rather complicated, but essentially one of the sticking points is that when you do that, wherever you're doing it, so I've had individuals have business trips and they do it in like a conference room or something, it has to be stated on the agenda first of all, so that somebody knows that you're actually participating remotely. And then in the conference room that you're doing it in, let's say you're in a hotel, you actually have to post on there that this is where the meeting is being held so that a member of the public can also address. But I think it's generally okay, it's just there are a lot of rules that come into play. So if it does come up, please consult us early so that we can make arrangements, especially if there needs to be changes to the agenda. Okay,
Do you have a question on this side?
go ahead.
D7.
Go ahead, Robert.
Thank you, Pete. Robert Sandoval, District 7. The policies that you showed us on the screen, are there into our orientation, or?
The policy. So policy. So policy 04 is a big one.
No, all of them. They're all here,
Policy 04 is not. As I mentioned, it was adopted yesterday and it's being revised in light of.
but everything
council.
else is in here.
The presentation will be provided to you after.
Okay,
afterwards,
excellent.
so
The reason I'm asking the questions for the other new commissioners.
sure. So as I mentioned early in my presentation, the presentation will be provided to staff and they'll decide how they want to distribute it to you, maybe in an email or something, or if you want hard copies, I'm sure they can facilitate that as well.
And I'm sorry, there is a draft version of the policy in that binder.
Just the draft, not the complete policy that he
The
illustrated.
old version, yes, nothing new.
Mhm.
that was adopted.
Right.
Did we have him before, Director?
Right, well,
Curtis?
you've
Yes.
actually commented on this within the last 12 months because the clerk has asked for commission comment, not just from this commission, but from other commissions, as they've been developing 0.4. It was passed yesterday, so it really hasn't been available in 24 hours, but two things, as John has stated. We can either arrange for a training where the clerk staff would come in and do kind of an overview of what the new rules and regulations are, or at this point, in January, all commissioners, will be invited to a mass training by the clerk's office going over the new rules and regulations.
No, it's not a question.
Yeah, just to follow up a little bit on that same thing, can you explain the difference between Policy 04 and the bylaws? Because we looked at this in October of 2014, and there were sample bylaws in an appendix on there, and we had some comments and we gave some input, and I think that's all that ever happened with that. But
Right.
what's the relationship between those two things?
That's a great question. So Policy 04, as I mentioned in one of the slides up here, is that, it governs a number of things. The template's important. The template that you commented on is important because that's going to be sort of the basis for all bylaws that should be adopted. And the bylaws, are going to have your individual governance stuff in there. I don't know that you guys have adopted bylaws. I don't think so.
They passed actually probably about 6 years ago under the pilot bylaws. But we were told to hold off on continuing implementation until the standard bylaws were formulated under 0.4.
Right, so it sounds like the new you'll have to adopt new bylaws, and it'll have to conform to the template that was provided, and it sounds like you guys have already commented on that.
Well, one of the issues was we're a little bit odd compared to the other commissions, mostly because of the caucus process that
Right.
elects us. Has that all been wrapped into that as far as you know?
I would imagine that the bylaws would also speak to the sort of caucus process. That would be a nice sort of tidy place to put it, I would imagine, but I'm sure you'll discuss this a little bit more as the process continues.
And then one other quick clarification on absences. We only have 10 meetings a year, so you said 3 in a row or 20% of the meetings. So to be clear, if we miss 2 meetings, we're out. Is that right?
20% of meetings, yeah, I get.
So that's
yeah.
2. Right.
Yeah, I mean, that
okay.
sounds like it, yeah. And the flip side of it is that there are only 10 meetings, so.
Yeah.
I have a question.
Okay.
I run a Facebook group called Fiscally Responsible Democrats. So that means I can oppose a favored ballot on that as a person, but not as a neighborhood commissioner.
Okay, so let me see here. I think that sounds right. So is that a ballot measure? Is that what you're saying?
Anything, because since I run it as a group, I actually post status in favor of a measure or against a measure.
I think the important aspect of it is, as you mentioned, is just to make that distinction so that when somebody says, oh, Harbinder actually opposes this measure, oh, the Neighborhoods Commission opposes this measure. That's the distinction you want to make, right?
Yeah.
So,
Yeah,
any
so,
other questions?
Commission members, if you have any questions, because we have a really tight agenda, send them to me and I'll send them on to the attorney's office for answers. Because we really do need to move the process along this evening.
Ernest, can I just say one thing? Yeah, my preference is to deal with things in email so I have a written record so I can give robust advice so we can nail down the facts. The facts really determine what the advice is going to be. And Pete, we discussed this, and it's great that you've done that. It's fabulous. So follow that example so that I'm not here sort of giving off the cuff advice and have to overrule myself. It's important that I get all the facts and thoroughly research it for you so you have the right answer, so you can make the right decision. Okay?
Thank you.
Thank you.
And Sean, just real quickly, the presentation at the PowerPoint will be forwarded to us by the attorney's office, and then we'll send you a copy of it for your record.